This is Attorney Clay Dawson of the Dawson Law Firm. Social Security disability, you've been denied. You get what is called a notice of uh, disapproved claim. It's the letter that denied you. The letter tells you what they considered, what evidence they had. They might tell you what evidence that they lacked, but they'll give you a reason why you were denied. They also tell you have 60 days to appeal, or they say you could reapply, but don't do that. You have 60 days to appeal. Then they tell you got another 5 days for mailing, whatever that is. So you better get it to them within 65 days. Other than that, you could lose all of your rights. Now, the appeal at this stage is called reconsideration. And there are many attorneys, many advocates that would tell you it's a waste of time. They'll tell you that reconsideration is a waste of time. It's just a speed bump on the way to federal court. And they tell you your best chance of winning is at federal court because you're going to have a judge there. And the judge is going to listen to you and see your plight, and that he, unlike everybody else, or she, is going to have some more empathy and sympathy. After all, the people that reconsider you, they're the same people that denied you originally. So why should they change their mind? It's a good question, and it's got an easy answer. And this is the whole gist of Social Security. It is a form-oriented area of law. When you applied, there are a limited number of forms to use. Social Security is getting a limited amount of information. So people that are denied there, when they're reconsidered, the same people are provided much more information. There may be much information that you couldn't provide them earlier. Now, you could provide them things like testimony of your family and friends. You do that not through a hearing, but you do it through function reports. You could provide them with medical source statements, treating source statements from your doctors, which are given more weight than the Social Security doctors. You could give them things like that, which will give them much more information. You could provide more medical records. You could provide better vocational records. You could provide better information about your medicines. Now, when you have a trained, skilled lawyer or advocate, they understand these forms and they understand what is required in them. There are great questions in these forms, but unfortunately, most people don't know how to answer them. There's one question, for example. Can you count change? Well, that sounds like, yeah, I can count change. I had a client tell me, yeah, he wrote down yes. I said, how can you count change? This is all about work. When you count change, that means you're giving somebody money back. You're counting their change back to them. And this gentleman had psoriatic arthritis of his left hand. He couldn't even handle the money. But that's why they want to know how this affects your ability to work. That's all disability is about when you're talking about Social Security, the ability to maintain a regular job. How does your disability prevent you from getting or maintaining a regular job, 40 hours a week, 8 hours a day? That's what they're thinking about. And that's the kind of answers they want. There's another question, which I think is a great question. And the question is, what do you do from the time you get up until the time you go to bed? They have like 3 lines underneath it. Most people think that they have to have the whole answer in those 3 lines, but that's not true. Look, that answer should usually take maybe 60 lines if you had it. You just use the back of the page. But if they put 60 lines down for every question, then the doggone disability report would be like 100 pages. So they will give you 3 lines to get your answer started on. Don't limit it to the 3 lines. They want to know. Don't put down things like read books, watch TV. It's not a full picture. When I begin those answers, I begin with getting up. How do you get out of bed? You'd be surprised how hard it is for some people. And I'll go on throughout the entire day until they get to bed. And even then, their day may not be over. They could get to bed. It doesn't mean they're going to sleep. So the reconsideration level, you have a number of more forms available to you. Helpful forms. And why should they approve you when they disapproved you first? Well, they give them more information. And here's something else to think about. That hearing that these guys are talking about that you want to get to, it takes 2 years. From the time you request a hearing to the time you get a hearing, it's going to be 2 years now. Last year, it was 12 months. Then it got up to 20 months last winter. And now it's right at 24 months. You don't think that the judges with that huge backlog aren't telling the disability determination services to scrutinize these cases more, to approve more cases, to look at them, and if they're meritorious, to improve them? I do. We've had considerably good results at the reconsideration level, but we push it. We make our case. We make a good case at this level. We will make the same case that we would at the hearing level, but we do it at the reconsideration level. We give them a chance to approve you. It's important to be approved. Now, disabled people, they can't afford to wait 24 months for a hearing. And then even after the hearing, it could take 2-3 months to get a ruling. Then after the ruling, it could take another month before you get a check. Disabled people can't afford to put a roof over their head. They can't afford to buy groceries. They can't afford to pay power bills. They're living off the kindness of other people, family, friends, and that's not unlimited. They need help now. That's why I believe that reconsideration is the best shot, and you gotta give it everything you have. The worst that's going to happen is you get denied again on reconsideration. Then you go through the hearing process. But don't give up on this level. This one can be the one where you are approved and approved quickly. They're not going to take 2 years. At the reconsideration level, you get your stuff in, and probably within 60 days, you're going to have an answer, approval or disapproval. This is Attorney Clay Dawson of the Dawson Law Firm. Thank you for watching.